Welcome back to Contemporary Business. I'm your host, Ivor Blumenthal, and I'm very pleased to be joined by Queen Munyai, who is the Chief Executive Officer of the Consumer Goods and Service Ombudsman's Office. Queen, thank you so much for joining me here on Contemporary Business.
Thank you so much, Dr. Ivor. It's a pleasure for me to be here this afternoon.
So what specific responsibilities does the Consumer Goods and Service Ombudsman have in relation to businesses, particularly small to medium-sized businesses, and how does it differ from its responsibilities towards consumers? There must sometimes be a little bit of conflicting interest in that regard.
Yes, thank you so much. I'm glad you asked that because the Consumer Goods and Services Ombudsman comes in as an alternative dispute resolution body. So we were set up in terms of Section 82, subsection 6 of the Consumer Protection Act. So our mandate is to mediate disputes that may emanate from any transactions that happen within South Africa between the consumer, the general public, and the supplier of goods and services, whether it's selling the products directly to the consumers or offering a service to the consumers. We operate in terms of the Code of Conduct, which was promulgated by the Minister of Trade, Industry and Competition in 2015. It came into effect in 2015. And from that time, it became compulsory for all the businesses that are trading within the goods and services industry to belong to the code. So we are there neither for consumer nor for supplier. As you correctly say, that it may seem a bit conflicting, but that is the nature of the Ombudsman or ADR, because we are there as a mediator. We stand between the consumer and the supplier, and we do not take sides.
So I just want to go back to something you said that you glossed over, but is the most critical aspect of everything you've just said. Since 2000 and let's say 2020, just for argument's sake, there's a law in this country that says that any business which is consumer facing, in other words, sells a good or a service to consumers, is required by law to register with the Office for the Consumer Goods and Service Ombudsman. Could you say a little bit more about that? Because I don't know how many businesses are actually aware of that.
Aware of that, yes. In fact, let me just take it a little bit, one step back, a little bit, Doctor. So the Office of the Consumer Goods and Services Ombudsman started operating in 2013. And when we were set up by industry as an Ombud scheme, because in terms of the Consumer Protection Act, every industry can set up their own Ombud. So what happened is that the industry came together with representatives already being facilitated by the Consumer Goods Council of South Africa to draft the code. And this code then gets proposed to the National Consumer Commission, and that is also in line with the Consumer Protection Act. So after public participation, gazetted, businesses, some of them did supply some or just present some comments which were incorporated. Then finally, that code it's now proposed to the Minister of Trade and Industry. That process went on, and the Ombudsman scheme at that point was in operation as a voluntary scheme. But as soon as it came to March 2015, the minister promulgated the code. He signs it off as law. And what it means is that now from that point, because it comes into effect in April 2015, from that point, it is now compulsory for anyone who is playing or who is trading within the goods and services industry to sign up to this code. And also there is an element from business side to pay some fees in order to run this scheme. So we are set up as a non-profit organization without members. Our members, we refer to them as participants. So the way we are set up, the funding model graduates according to how much revenue the supplier or the business generates. It starts from SMME. And the good thing is that on setting up this Ombud scheme, Businesses that generate less than 1 million per annum, although it's compulsory for them to sign up, they don't have to pay anything, which means that the scheme provides for cross-subsidization. Big business carries the cost of having an ombud, while small business benefits from the scheme, but they don't have to pay financially if they generate less than 1 million per annum, which is a good thing. So the fees graduate according to the size of business.
Let me ask you this question, Queen. And I'm talking to Queen Munya, who's the CEO of the Office for the Consumer Goods and Service Ombudsman. What happens if I've been operating a business long before 2015, but since 2015 and until 2024, I've not been a member of the Office for the Consumer Goods and Service Ombudsman scheme? Is it a case of me just joining now and letting bygones be bygones? Or in fact, have I committed a criminal offense?
Yeah, sadly, you have. Because ideally, everyone who's trading within the industry should have signed up from the time when the code became law. But the good thing is that when the board, because the board is the one that is entrusted with the authority to set up from time to time to decide on the funding model and all that. So at the moment, the board has resulted that we are not going to be punitive to those businesses that delayed to sign up. However, starting from year before last in 2022, we implemented what we call it's a penalty fee, but it's quite minimal in that it is now being introduced after 10 years of operation of the Ombud scheme, just so that the ones that are signing up now, they don't have to go all the way back and pay the fees from the time when the Ombud became active or became compulsory. They make a small contribution, and it's a once-off payment as a contribution of the infrastructure and anything that was set, the setting up of the organizations for the past 10 years. So that is all that they have to do. They don't have to go all the way and pay all the fees, although we could go that far, but we are not applying that. We are allowing them to sign up when they sign up right now and only contribute that certain percentage that goes to the setting up of the organization. And going forward, it's just an annual fee that they will pay according to their size. Currently, it's sitting as, maybe to be precise, it's a 25% of the annual participation fee.
Okay, so it's 250 Rand. So if my 50,000 Rand is 250 Rand. So Queen,
yes,
really the question is this then, why? In other words, what is the purpose of me having to join the scheme? And I assume it's so that my customers then have recourse through the Office of the Consumer Goods and Service Ombudsman to my company should there be a problem with a product or a service in the scope of the problems you would deal with.
The idea of the Ombud scheme is to mediate complaints, and we become an alternative to the courts. Doctor, you are aware of the litigation costs. It's so much expensive. But the CPA provides for this ADR process, the alternative dispute resolution, which is cost effective. Our services are free to the consumer. To the supplier, it's a small contribution of the fees that we've spoken about. And it's to make sure that if anything goes wrong, and especially now in the era of AI, of digital trading and all that, social media and everything, as an alternative to consumers going viral on social media or on other unregulated spaces, there is an Ombud space, which is a fair process, which comes in and become impartial in both parties. So it is important and also reasonable for a business to be able to have such a platform where complaints can be handled in a fair manner without taking side by an independent party. Because a lot of time, although the code requires that each business must have their own internal complaints handling process, we are not a replacement of that. You still have that, but if that level fails, you know that there's another body who is independent that can come in and facilitate the resolution of this code. So, I mean, it helps to make sure that our consumers, I mean, we are there to promote fair business practice in the industry. We want to make sure that consumers still get quality, still get, you know, fair service and just, and, you know, making sure that we are protecting them from unjust or otherwise improper trade activities. Because while there's businesses that are proper and running correctly in the industry, there are also ones that come in, you know, to take consumers for a ride. So we become that body that makes sure that that is happening, you know, in a just manner. So it is of importance that every business would belong to this scheme, and also give redress to your consumers to maintain that relationship, so that if the consumer gets their redress, the chances are that they will come back tomorrow and make business again with the same supplier. And that is the whole spirit of the Consumer Protection Act.
And my assumption is that the company then is free to advertise that it is a member of the Consumer Goods and Service Ombudsman. So should a customer have any problem with the quality of their product or their services, they can appeal to the Office of the Consumer Goods and Service Ombudsman for recourse. Can I ask you this question? Are your staff in your office who deal with these disputes, who mediate these disputes, are they trained, let's call them commissioners, are they trained as commissioners to be able to mediate these disputes properly?
Maybe to start with your first comment, when suppliers sign up, we do give them decals that they can put on their website. Those that are having brick and mortar stores, then we give them decals that they can put on the doors of their stores, which advertises that they uphold the provisions of the Consumer Goods and Services Industry Code. Thus, to give confidence to the consumers that if anything goes wrong, the supplier is willing to come to the table and you know, engage for a fair treatment to the consumer and give redress if it's due. Second question of whether my staff are trained or they are qualified, definitely yes. So we do have a group of lawyers that sits, we call them the complaints officers. So we've got, some of them are admitted attorneys, some of them are LLB graduates. So we also have adjudicators, and we also have the Ombudsman himself. So we've got qualified staff that are sitting and waiting and are dealing with these complaints, making sure that the law is interpreted correctly, and it also stands as giving advisory to the businesses. Sometimes you find that businesses encounter a very difficult consumer, and sometimes no matter what they offer, the consumer doesn't go away. So they can escalate. Not only consumers can approach us to escalate complaints, even suppliers can say, we have done what we were supposed to do, it's not helping. But here is a case, please facilitate on our behalf. In fact, you can actually tell your consumers to approach the Ombud office so that we can become of service even for you. So that is the benefits of being part of the Consumer Goods and Services Ombud.
I think that's a fantastic explanation. Just as a technical point, so who is the Ombudsman? Is it not the Office for the Consumer Goods and Service Ombudsman, or are you talking in generalities, the entire office constitutes the Ombudsman?
The office, the whole office is called the Ombud office. We call it the Ombud office, but we've got the Ombudsman, who then becomes the who gives to the office, in other words, if I may say it that way.
So who is the Ombudsman?
Over and above, it's Lee Sobrati. Liquid Sobrati is the Ombudsman currently, who started office. He took on office in July 2023. This is the third Ombudsman since inception. that we've had.
Who killed off the first two now that
So I think it's an element of, as we are growing, people move on. And also the code prescribes that the ombudsman's tenure, it's prescribed by the code. So they are allowed to serve a certain period and for the purpose of independence also. So they move on, then we, according to the code, we also go to the market and appoint the new ombudsman.
Before we talk about the relationship with SAPMA, which is an industry body, but before we talk about that relationship with SAPMA, I want to ask you about precedent, because presumably you deal with a fair degree of precedent in your business, and essentially you deal with an opportunity to create frequently asked questions rather than necessarily having to refer every single issue through as a dispute. So how do you deal with precedent in terms of bringing it to the eye of the public, but also bringing it to the eye of the member of the Consumer Goods and Service Ombudsman?
So what we do, we keep stats of what is happening. On a quarterly basis, we produce a newsletter. And newsletter, we report what has been happening, what we are seeing on the ground. We'll report even if there are any trends that we pick up in the process of dealing with complaints. We would report on them on our newsletters, but also we do have a process where if we pick up any trends, we report them to the National Consumer Commission, who have the powers to investigate and to make binding rulings, which as the Ombudsman we do not have. So our office uses what we call mediation, and our staff is trained to mediate, but we do not make binding resolutions. What we make in terms of the code is recommendations in terms of the law. So if there are any trends or any precedents that we are seeing, it also helps that even on our website, we provide for a space of frequently asked questions, as you correctly say, wherein what we are picking up as the most of the questions that are being directed to us, we add them to the frequently asked questions, and we put in the answers that helps to, and those talks to the majority of complaints. For instance, if the complaints that we are seeing are relating to Section 56 of the Consumer Protection Act, which talks to the implied warranty, for instance, we would put it there to say, in terms of the code, there is an implied warranty of 6 months for any goods and services that you get in South Africa. If something gets defective within 6 months, you have, as the consumer, have the right to claim either a repair, a replacement, or a refund. So we put it out there so that a general public can have knowledge. And the case studies, typical complaints that we pick up on the market, we also put some case studies on the newsletters and on the annual report. On an annual basis, we are required to produce an annual report. So on that annual report, we also put in some case studies to help bring this law and our office to life, so that somebody can see how it plays out in practical.
That's absolutely essential, I think, because you're an enabling body rather than simply a reactive body. And I think that that's critical in terms of the role of the office. It brings me now to the fact that there is a memorandum of agreement between your organization and industry bodies, such as, for example, the South African Paint Manufacturing Association. What's the benefit for a member of SAPMA knowing that their industry association is in an agreement with the Office for the Consumer Goods and Service Ombudsman? What peace of mind are we giving that member, who frankly should also equally be your member, in terms of having signed up with you?
That is an advantage, I think, to the members of SAPMA, that their association is now collaborating with the Office of the Ombudsman, in that we want to make sure that, I think they kind of, it kind of gives life to what I was saying earlier, that our role is to make sure that there is there is fairness in the industry, because one of our part of our mission is to raise standard of good conduct in the industry. So that gives comfort to a member to know that the ultimate purpose is to make sure that there's good conduct in the industry rather than just individual shops. So you operate within a community of fellow service providers or businesses that are ethical and are willing to make sure that the level of business that is being conducted, it's a fair one, and we are not taking consumers for a ride. So I think that is an advantage. But also, there is an element of saying that based on the agreement that we are having with SAPMA, is to say that there is a CPA training that we give to suppliers. So SAPMA becomes a first level to make sure that they make sure that all players within their sector are adhering to the Consumer Protection Act. And they are very close to the suppliers than us as the Ombudsman. So that means they can facilitate and assist. And where there is a gap, they can then talk to us and give us feedback, but also give us input in terms of what is happening. Because we believe that in SAPMA, they are a body of experts within the paint industry, for instance. As the Ombudsman, we may not necessarily have all the expertise in as far as paint is concerned. So that is another added advantage, because in the case where we get a complaint that requires technical input, then SAPMA has those technical knowledge that they can assist in giving what are the regulations regarding painting, or what are the standards that have been put. Because I would believe that as an association, there are standards that are given to the people that are giving service to the public, that, for instance, those that are mixing paint, those that are doing the actual paint work, what are the standards that the association stand for? So our collaboration with them, even the information sharing and all that, helps solidify this process that we are trying to enforce and make sure that there is fairness within the industry.
So, Queen, it's been an absolute pleasure chatting to you. And I, for one, am looking forward to this relationship between SAPMA and the Consumer Goods and Service Ombudsman, particularly in terms of solidifying the notion of guarantee of paint, but equally warranty of application of the paint, to make sure that we don't necessarily duplicate each other's activities. And also, frankly, importantly, to make sure that every one of SAPMA's members complies with what should have been complied with from 2015 onwards. So it's a great opportunity for us to work together, to build a body of knowledge, and to rope in the subject matter experts, as you've said, from the paint manufacturing, the paint supply sector, and the retail sector, who can assist you in your mediation activities, so that arbitration and court cases can in fact be avoided. Because I think that's what we're jointly doing. We're allowing for issues to be ventilated at a level that it's not a menacing oppositional environment, but hopefully a cooperative environment. What do we do finally in the case where there is for argument's sake, a supplier, manufacturer, or a manufacturer retailer argument in the process? Does the Office for the Consumer Goods and Service Ombudsman get involved in those kinds of, let's call them business to business disputes, or exclusively business to consumer disputes?
Okay, so in terms of the Consumer Protection Act, it covers the supplier whose income or revenue per annum is below 2 million per annum is classified as a consumer. So where there is a B2B transaction between that supplier and the bigger supplier, they are covered. They can complain to the Ombudsman. But unfortunately, for businesses that are above 2 million, they cannot be covered. They are not covered under the Consumer Protection Act.
Queen, thank you so much for chatting to me here on Contemporary Business, and we look forward to doing business with you on an ongoing basis.
Awesome. Thank you very much, Dr. Evo. It's a pleasure for us to be here. Thank you for having us.
Thanks very much. Keep well. Bye-bye.
Bye.